These people sponsoring. Sponsorship I'm not going to mention this. Well, a warm welcome, ladies and gentlemen, from a magnificent Cape Town. It's a blistering afternoon here inside, but it's nice and cool outside. And it gives me great pleasure on behalf of the Pelvic Floor Foundation of South Africa to welcome you all present. There's many hundreds of you logged on, and it's wonderful to have such a good turnout for the first of the season's presentations and offerings for 2024. My name is Peter de Jong. And his name is Professor Steve Jeffrey. It's wonderful to have you here, Stephen.
Yeah, thanks. It's obviously my first webinar, and it's great to have all of you. It's quite a lot of you logged on already, and hopefully we're going to have a good season of webinars in the next this year. And so thanks to Pete for being a part of this and for getting us started.
Thank you, Steve. Yeah. Well, the presenter this afternoon, ladies and gentlemen, is a person that is well known to us. He's an attorney, a defense attorney, and he's no stranger to medical malpractice. His name is Clayton Hall, and the topic is informed consent, the hows and whys and do's and don'ts of medical malpractice. He's greatly experienced as a medical malpractice and defense attorney, and a consultant to the insurance and healthcare attorneys, industries. So without further waste of time, Clayton, are you with us? Can you share our screen, please? There he is. and he's sharing. There he is, Clayton Hall in the flesh, as it were. Wonderful to have you over here, Clayton Hall, to start us off in the new season, episode 1 of season 4, the hows and whys and do's and don'ts of malpractice and informed consent. Clayton, I hope you can give us a few minutes at the end. We've got a whole lot of questions already lined up, and if it would be wonderful if we can just delve into those and answer those. Clayton Hall.
Absolutely. Only too happy, and thank you for the warm welcome. It's great to be back, and it's always wonderful to chat with you. Ready for us to get cracking?
Please share your screen, and we'll obviously interrupt you as you go along if you don't mind.
Please do. It's always better when it's interactive, and we get the most out of it when we're answering questions that actually matter to people. So always happy for that. The share is incoming. There we go. Is it up?
Clayton Hall, Head of Legal Defense.
There we go. That's me. So let's talk a little bit about informed consent. And as we've said, please feel free to hop in and ask questions at any time. Just a little bit about NatMed. So we're insurance brokers specializing in medical malpractice, which we've done for the last over 20 years. We do insurance cover for private practitioners and healthcare facilities. As brokers, we obtain it. We don't provide it ourselves. And I don't need to introduce myself because I've already had a better introduction than I could give for myself. Where we'll start, and please forgive me, I am a lawyer. I know that this is going to be a little bit dry, but I'll do my best to make it less so. And we'll go as quickly as possible through the legal part. But it is important to understand where exactly the requirements for informed consent actually come from, and they're not in one place. We've got elements of it in the Patients' Rights Charter, where it really is the manifestation or the execution of that comes out of the Constitution and the rights enshrined there. The National Health Act, Children's Act, Mental Health Care Act, Sterilization Act, Choice and Termination of Pregnancy Act, and of course the HPCSA guidelines. And there are even other areas than this. When we look at the common law, which is the difference between legislation, regulation, and common law comes from out of our cases, whereas the legislation and regulation is what the legislature sees fit to actually write down to give to people as a guide. But in the common law side, failure to take informed consent and then to proceed with a surgical procedure really actually fits the definition of the crime of assault. It's the act of inflicting physical harm or unwanted physical contact upon a person. And you can see in that case, there's no difference between stabbing somebody and making an incision with a scalpel, except for what we call a justification defense. And so within our criminal law, we have to have a whole bunch of elements present. One of them is that the act must be unlawful, and consent removes the unlawfulness of the act, and therefore it is not a crime. Without the consent, it actually fits all of the elements of the crime of assault. The maxim that we have in law is volenti non fit injuria. It's Latin for I have no idea, but the actual explanation of it is that no harm is considered done to somebody who consents thereto. There are limits to that, of course, as there are to most things. You cannot consent to things that are outside of the good morals of the community. So you can't simply walk into a hospital and say, "I'd like you to remove my leg, please." Can't consent to that. It's not considered consentable. So we'll hop a little bit into the legislation, and I, of course, am not going to read you all of the acts, but I will just highlight some of the components that really matter for consent. There is more than what I'm going to read to you now, of course, or discuss with you now, but these are the kind of salient points. So just in the Patients' Rights Charter, it's to ensure that the realization of the right to access to healthcare services, which is guaranteed in the Constitution, that's the purpose of the Patients' Rights Charter, And right there, it's got two sections going, you have a right to participation in decision-making and a right to informed consent. So you have the right to participate in decision-making on matters affecting your health, and you have the right to be given full and accurate information about the nature of your illness, diagnostic procedures, proposed treatment, risk associated with that, and the costs involved, without which you actually can't make informed decisions in order to adequately participate in decision-making on matters affecting a patient's health for the patient. We also have the National Health Act, of course, where it specifically states that a user, which is, for all intents and purposes, can be read as a patient, but it's a user of healthcare services. So the user or patient has the right to participate in any decision affecting their personal health and treatment. And the rights and duties of users and healthcare personnel, when we look at certain areas. So there's emergency treatment, right, where you don't necessarily need to get the consent beforehand, but must of course inform the patient of what transpired afterwards. And the user is to have full knowledge. Now that's a really difficult thing to do for somebody who is not a healthcare practitioner when you're explaining something that is quite complex because they don't have medical degrees. So what do we actually
Clayton,
need? Yes.
Sorry, Clayton, can I just ask a question? I'm reading over here and it says, the first thing is that the Constitution says you have right to proper access to healthcare. And as far as I know, that is balderdash because there's many people, particularly in rural areas, that have no access. So where does that put it? And secondly, a user here reading your first line has the right to participate in any decision affecting his or her personal health and treatment. And I also know that's not true because I do work in the state sector. And if a woman walks in and wants to participate, for example, in the mode of delivery, say for whatever reason she wants to have a decision as to she can have a Caesar or not, they'll tell her to bugger off. Now, how does that wash with this particular printed information that they have access to?
Okay, great questions. The first one is answered by Section 36 of the Constitution, which is that all of the rights that we've just said all have limitations, and many of those limitations are as a result of the resources that are available. So it's within the available resources that the state has. And so if if you can't provide that treatment, then the limitation is, yes, well, we don't have the funds to be able to do that. So that's the limitation.
So that's like a disclaimer. In other words, they could say, well, we can't give you what you want because we don't have the... Now, what happens if it's something really basic, like a toilet and a pit toilet in a school? They have sufficient resources to indulge in certain practices that we won't go into, but they don't have sufficient resources to make toilets for children in schools.
Yes, the limitation it has to be reasonable, and so those are all open to constitutional challenge, which is why in some cases the provision of toilets in informal settlements has actually been challenged on the constitutional basis. That the fact that it hasn't been done just on the basis that there are insufficient resources is not reasonable, because there are sufficient resources. They just need to be applied properly in the correct priority. And that basic sanitation is an extremely high priority and must be done. So there have been cases that have been won on those.
Thank you.
So yeah, that's where the challenge to the limitation comes through.
Right.
It's normally by organizations that are act in the public good. In the second, the user has the right not to make any decision and to have that decision carried out. They have the right to participate in a decision affecting their health and treatment. And that participation, once again, has limitations. Much like you can't consent to have your leg chopped off for no good reason, there has to be some therapeutic benefit to treatment. Otherwise, it's not defendable. So unless there, and that's what healthcare services are, right? There's a therapeutic benefit. A lot of the things that we do in healthcare would be considered assault, even the giving of medication. If you give somebody who's unaware of medication, that is considered assault. So really, it's within the bounds of what's available, and that limitation on giving birth one way versus the other, you would be given the choice to have a cesarean section if there is a medical indication for a cesarean section. But the policy and again the resources available say that we can't offer anybody a cesarean section merely on choice. And so, although you have the right to participate, as I say, you don't have the right to have any treatment given.
Thank you.
It has to be again with the limitation. So there are a few things that you have to inform the user of: their health status. Also, everything always has exceptions, unless informing them of their health status would have a detrimental effect on their health. The treatment options that are available, the benefits, risks, costs, and consequences that are associated with those, and the right to refuse health services, which includes the necessity to explain the consequences of refusing those health services, and should be in a language the user understands and that takes the user's level of literacy into account. There's more in the National Health Act. A health service may not be provided to a user without their informed consent, and there are always exceptions. So if the user is not able to, but consent is given by a person mandated by the user or authorized in terms of any law or court order. And an example here is the Mental Health Care Act, which authorizes the admission of certain people under certain conditions without their consent. But that is because it's authorized in terms of that law. Where a user is unable to, and there isn't anyone who's mandated or authorized, then the consent can be given by a spouse or partner, parent, grandparent, adult child, sibling, or sibling, but it's in that specific order. So hopefully the spouse or partner is available. Otherwise, you're going for the family tree. The provision of the service without informed consent is authorized by a law or a court order. And that's just not that the user is unable to. This is the user could be able to, but the provision of that service without it, even if they're able to give it, is already authorized by a law or court order. You don't have to get their consent if failure to treat them or treat a group of people that includes them will result in a serious risk to public health. And you don't have to get their consent if a delay in providing the health service in order to get consent might result in their death or irreversible damage to their health, and they have not specifically refused that service, either expressly, impliedly, or by conduct. And so
Clayton,
yeah.
No, carry on. We do have two questions.
I was going to say one of the things that we're building into the informed procedure-specific informed consents is actually areas where you talk about additional procedures that may be required, if certain things happen, and providing space for users to specify if there are any procedures that they do not want performed, even if they're indicated intraoperatively.
Yeah.
So did you say, sorry, just to interrupt Stephen over here, I was going to ask two questions.
Mm-hmm.
Did you say specific procedure-informed consent that you're building? Are you, as a firm, formulating and crafting and framing informed consent forms for people to use in ONG?
Yes, we are.
And when will they be available, Clayton?
It'll be this year. The first, so we're putting out our practice letter within the next couple of weeks, and then thereafter we'll start publishing the informed consents. Within that, we've also got informed consents for the whole of the antenatal course with full descriptions of everything, all the tests available, etc., the consequences, where the decision-making points happen, with diagrams and flow diagrams and real, everything you can possibly hope for patients to have these things explained to them.
And will this be free to your clients?
Yes, it will.
Okay, thank you.
In fact, it may actually be free to everybody because I think the benefit of having well-structured informed consents is a benefit to everyone, including patients, and not something that should be restricted only to our clients. So it is something we will be publishing more broadly as well.
So there are three questions or sort of comments from Leon Null. How does the principle of informed consent play out in the era of mandates for any medical procedures or medications? Do you understand that question?
I don't.
Okay. Mandates, is it...
Okay, maybe you can ask Leon just to clarify that.
Yeah. And then, yeah, I mean, I think it's a very interesting area. I mean, most of us do end up seeing foreign patients. And how does that access to care and your legal and ethical responsibility to caring for someone of a foreign passport can be quite tricky. I suppose emergencies do need to be covered in a state sector area. But I suppose when it comes down to elective surgeries, those are something that, you know, one does need to you know, possibly decline. I mean,
Can they be refused?
Yeah,
Can
what is your opinion on that?
if they have a fibroid, can you refuse to do myomectomy in the state sector, for example? I think that's
which is a common problem.
I think that's what
Yeah.
the person means, anonymous.
Yeah.
How would you respond to that, Clayton?
So with this, I think, and I haven't actually looked into this, but if I consider what I know about the law and the rules around this, when you are in this country, you're governed by this country's laws, and you're governed by this country's rules and regulations. So everything that applies to other patients who are citizens applies to non-citizens as well. They may have expectations based on whatever the procedures and processes are in their own countries, but you do not have to implement the rules and laws around informed consent that come from wherever they're from, because this is where the treatment is, and it's the rules of South Africa that get applied in this country. What you do
I think, yeah.
I was going to say, what you do need to be concerned about is things like post-operative care. You know, where are these patients actually going? When are they going there? There's follow-up that has to happen. And so I think there's just additional questions that have to be asked, and there are additional, you know, particularities for treating foreign patients to ensure that that you've really got the full kind of post-operative course planned, and that you know that they'll have recourse if there is if there's a complication that arises. So if they are going straight home, you need to be extra cautious in informing them of what to look out for and who to contact and where to go.
I think the bigger question really was, you know, what happens if you've got a patient who arrives on you know, on the doorstep of a hospital as a foreigner who wouldn't have legal recourse to treatment, being a foreigner. I mean, this happens quite a lot, especially in the state sector, where these patients end up and they get denied treatment because they're foreign nationals. And
yeah, sorry. So I was thinking about it from the lens of informed consent, right? How do you treat?
Yeah. No, sorry. You were just saying rights, universal rights, access to care as an individual.
Right. No, I must admit, I don't know what the rules are. I haven't looked at those around foreigners having access, unless, of course, it's an emergency, in which case the rules are clear.
Okay. Here's a quick question from Marcus Faison. How does vaccination fit in here? Steve, you've taken it away.
Yeah, sorry.
How does vaccination fit in here? Can parents refuse to vaccinate their children even when the benefit is proven beyond any doubt? A quick question, because there's so many questions. We don't want to sort of hijack your talk here in this stage, Clayton.
Yeah, I mean, let me answer this one and maybe just keep a couple for
the end. All right.
But with vaccinations, yes, parents can refuse unless the state has mandated that a particular vaccination is mandatory. But there are, as always, limitations. And so usually something like that would have a limitation where you can refuse on specific grounds, but then those grounds would need to be justified. Otherwise, you don't require consent because it is under that catch-all of if it's going to result in serious risk to public health. So I could have, I don't know if there are any of those specifically, but in the general course, you can refuse to vaccinate unless it is mandatory because of risk to public health.
And just to follow up on that, Caroline Ramashaba says, can you touch in pediatrics? If a family wants to take a minor child out of care and the minor needs care, is that legal?
Okay. So
for example, a Jehovah's Witness perhaps that needs blood. Can the family refuse?
It depends on age. So, and we'll touch on that under the Children's Act in the next couple of slides.
Okay.
Let me answer that question there. But the what's the way forward if the family does have the right to make the decision for the minor, and they want to take the minor out of care, or as you say, that the minor needs blood, they're Jehovah's Witnesses, then the answer is that you get a court order. So, lots of law firms are set up to do urgent applications for this. They can have the order done, in a matter of hours. They've got the judges on speed dial who grant these things, and it can be done very, very quickly.
Okay, please continue, Kate. We'll come back to Lionel. He's clarified his question, but we don't want to hijack your talk. Thank you.
Thanks very much. So, and then also, just that last point, you must take all reasonable steps to obtain the user's informed consent. And I know it's all reasonable steps. So if there is a reasonable step available to you, you must take it. But if any of the steps available to you are unreasonable, then you don't have to. And what's reasonable and unreasonable in the context is whatever the reasonable person in that situation would do. That's not very helpful because it just repeats the same definition. Under the Children's Act, so a child can consent to their own medical treatment or to the medical treatment of their own children if they have any, if the child is over the age of 12 and they have sufficient maturity and the mental capacity to understand the benefits, risks, social and other implications of the treatment. So they need to actually be able to really understand, and it's the practitioner who has to make that assessment. A child can even consent to the performance of a surgical operation on themselves or a child if they have one. It's the exact same conditions as above if they're over the age of 12 and have sufficient maturity and the mental capacity, except that you also have to be assisted by a parent or guardian. So not if the child alone is insufficient. If the child is under 12 or they're over 12 but they don't have the sufficient maturity and mental capacity, then a parent or guardian or caregiver has to consent to the medical treatment, or only parent and guardian for surgery. So caregivers can give consent for medical treatment, but not for surgical procedures.
Unless they're pregnant, the children, because then they're considered adults, aren't they?
Well, there's actually special rules written into the acts around pregnant minors.
Children, yeah.
There are a few other special cases. So one, the Sterilization Act. You may be sterilized if you're 18 plus and capable of consenting. The flip side is if you are capable of consenting, then you may not be sterilized without your consent. You also can't be sterilized if under 18 unless there's a risk to life or serious impairment of physical health. And if you are before sterilization, you must ensure that the patient has been given advice that they can withdraw that consent at any point up to the performance of the procedure. They have to be given a clear explanation and an adequate description of the procedure plan, so what is going to happen from start to end, and the consequences, risks, and specifically the reversible or irreversible nature of the sterilization procedure. And extremely importantly, the Act specifically says they have to sign the prescribed form, which means that sterilizations have to be in writing and they have to be signed by the patient. There are many cases that we have seen where sterilizations are performed and it is not, the consent is not in writing, or it is, there's a note about it, say someone's coming in for a Caesar and you haven't really discussed sterilization and you're on the way to theater and they're like, oh, by the way, I also want to have a sterilization. You have a quick chat and like, great. Well, you're not allowed to do that. It has to be in writing. It has to be signed.
Is that's only for sterilization?
Yes, specifically for sterilization.
Because written and there's another question, verbal consent, is that as good as written consent as informed consent? Does informed consent have to be written?
Informed consent does not have to be written.
Right.
Except where legislation or regulation requires that it be written, like in the Sterilization Act.
Right.
Yeah, but it is inadvisable to do informed consent for major surgery or for surgical procedures that have risks of complications, because you want to have a record of what has been discussed. At the very least, you want to have a record of the fact that something has been discussed and have that be signed by the patient. Otherwise, you enter the he said, she said territory. You also could avoid having to have it in writing if you record the informed consent discussion, so that there's a record in some other form of that discussion having taken place and what was discussed and what was accepted by the patient.
But that's another talk.
Yeah, we can talk about that when we talk about confidentiality. Under the Choice and Termination of Pregnancy Act, the termination of the pregnancy cannot be done without the informed consent of the pregnant woman, and no consent other than the consent of the pregnant woman is required. Of course, there to all of this there's always exceptions. They're quite detailed, but we don't need to get into those today. And for pregnant minors, there's an additional note to advise them to consult with family and friends before the termination, but don't refuse if the minor chooses not to do that. Of course, we also have the HPCSA guidelines, which are very helpful and quite extensive, and just a few kind of highlights from those. So informed consent, it's an exercise of an informed choice by a patient who has the capacity to give consent. They have a right to information about their conditions and the treatment options. They have a right to information about conditions of disease. And you can see that these are echoed already from National Health Act, from the other acts. Really, the HPCSA guidelines are a way to bring all of the rules from all of those places into one place to assist practitioners to not have to go and find all of the bits and pieces from each of the different sources. They have to do their best to find out about a patient's individual needs and priorities. You must not exceed the scope of the authority given, except in an emergency. And that's except in an emergency unless the person has already given you an indication that they do not want that done. A healthcare practitioner should explain how the decision to be made about whether or not to move on from one stage or one form of treatment to another. Raise with patients the possibility of additional problems emerging during a procedure, and of course, what would happen in those cases.
I think, can I just ask you something? So obviously covering all those points in one patient is quite a lot. And I mean, obviously you have your standard consent form, which would generically cover some of that stuff. But I know some doctors are starting to record some of their discussions with patients. What do you think of that option? I don't do it. I don't know if you do any of that, Keith.
No, patients don't like it, some of them, Steve.
Is it an option? I mean, and what do you think of that?
It's also on that very point, Clayton. You just sent us recently that we should have chaperones, and I have a chaperone, and a patient objected to the chaperone, but only afterwards, after she'd walked out of the room. She says, "Who is that dame that you called a chaperone, and why was she listening to our conversations and things?" And I said, "Well, she's a chaperone. The guidelines say she has to be there."
So, in actual fact, the chaperone must be offered. The patient must know that they have a right to have a chaperone present. However, the practitioner also has a right to have a chaperone present if the patient has elected not to have a chaperone present. You might want to have your own protection in the case of intimate examinations or consultations.
Yeah.
Of that nature. And so the rules are
really, isn't it?
that you must make them aware that they have a right to have a chaperone, that they can bring their own chaperone, or you can provide one for them. If they do not want to have a chaperone, but you do want to have one, then a chaperone, they can consent to the chaperone being present. If they do not consent to the chaperone being present, you as the practitioner may refuse the treatment or consultation.
Okay, and would you do that? Because that's going to open a can of worms.
It's your right? So let's say you have a patient that you're aware of, that you've seen before. Not all patients are incapable of giving consent, but yet appearing completely sane. There's a gradient in the middle there somewhere, and I think we've all, certainly from my side, because I see all the cases. There are quite a few of those patients who are not particularly reasonable, And if you are wanting to treat a patient like that, and you are at risk because you don't know what they're going to say or what they're going to do or what they might make up after such a consultation, then to protect yourself, then you would. In most cases where patients are known to you, they're relatively stable people, you might not choose to do that. So it would probably be in the more extreme cases where you would refuse treatment or refuse the consultation if there's no chaperone present.
Thank you.
But if you have a chaperone and there are you have to explain at the beginning why they're there, what they're there for, and that the patient has a right to refuse to have them present.
Thank you.
Pleasure. So before we get into the informed consent fundamentals, I think we do have still a little bit of time to do this. I'd like to do a couple of polls, if I may. Karen, would you mind bringing up the first poll for us?
What?
Okay, so the question is there. In your experience, how well do patients recall what was explained to them in informed consent discussions? And we'll just give you a minute or so to select your answer. And in fact, while that's happening, I missed one of your failed to answer one of your questions, which is around the recording. So I think it's not necessary in all cases, but it is a nice, if you're taking a bit of a belts and braces approach, it is really helpful to have. The reason is I had a recent case where the practitioner was reported to the HPCSA. In the complaint to the HPCSA, which was it was a lengthy and detailed complaint, this patient said that they were not informed of what the procedure was going to be, what the consequences were, any of the complications, etc., etc. They hadn't had the actual nature of the procedure explained to them adequately. It was why would you even be in the theater if none of those things were explained to you? And the practitioner had an informed consent form, which was not very detailed. It had a few procedure-specific elements, but most generic elements. But they also had a recording. And in the recording, it is extremely clear that every single aspect was explained to the patient. The patient acknowledged it. The patient acknowledged that they understood. They were given the opportunity to ask questions. They said, I don't have any questions. And that's it. HPCSA says, well, there's no unprofessional conduct, and good day. So, in that case, would it have been enough to have just a written informed consent? Maybe if it was a little bit more detailed, yes, and maybe even that more generic one would have been satisfactory as an indication that it was done. But to have that have the recording was a slam dunk.
Thank you.
Okay, so let's see how. Oh, that's not too bad. Maybe half is it's better than I was expecting. 59%, not very well. At least we don't have very many next to nothings, and total recall can't really be expected. So between the well and maybe half, we've got about 64%. That's a good 2/3 of patients. Okay, and then for those who don't really recall it very well, we've got to have some sort of backstop for them as well. Some written information or information leaflets, or at least links to places online where where they can go and repeatedly view either a YouTube video or repeatedly view just a list of what the nature of the procedure is, what the consequences are, what the complications are, etc., etc. And there's loads of resources online, which aren't all necessarily 100% complete, but will do a 90% job fairly well. If you wouldn't mind, Karen, just one if we could have the second poll up, and then we'll get on with it.
Two.
So just a question, have you ever had a claim made against you? And this a claim could be at the HPCSA or you know, a letter of demand or actual litigation that you successfully defended with a signed informed consent document, or specifically because of having a signed informed consent document.
Now, while people are considering that poll number 2, all these things, as Steve alluded to, Clayton, take time and therefore money. I mean, if you're going to have your patients have a detailed explanation, that's what they deserve. Plus, it must be recorded. Someone must capture that recording. Somebody actually has to catalog that recording and keep it in some form of recording diary. And then you're going to have a technician that does it at the end of every day, which might take 20 or 30 minutes. All of this costs money. And unfortunately, not everybody's in a position, if you have a very large practice, to perform these things. And also, you have to, before you start the recording, again, explain to the patient that this is going to record. Then she's going to say, why? Why are you recording? Then you've got to explain why. And she says, is it necessary? And then the whole thing gets a life of its own, does it not?
Yeah, I mean, this is a perpetual problem, right? The medical aids don't pay for the extra time required to do the informed consent. Doing it very properly, you know, takes time. Doing a slapdash job is quicker, but doesn't have the effect, and it's not real informed consent. But there is, as with most things where there's the limitations, there is some degree of reasonableness in this, where how much time and effort you spend on informed consent should be proportional to the treatment or procedure that is going to be provided. So you know that if you're going into, you know, major spinal surgery, for instance, that's going to require informed consent to be done very well, because there's a lot to understand there to make an appropriate decision. And there's real decision making that has to happen, because the alternatives and conservative treatment in many cases are very real alternatives. But in some cases where, for instance, you know, you're putting in a stitch in someone's finger because they nicked themselves with a knife, you're not going to spend 10 minutes doing informed consent. You're going to say, hey, I'm going to do this. Are you happy with that? Yes, great. And that's it. You don't have to spend ages on it. There are going to be cases somewhere in the middle there, right, where it's not that big a procedure, but you still have to do quite a detailed explanation. And what we're suggesting for that is to make use of documentation, whether that's in an online form that people have to click through, or printouts, or just links to something online that the patient can review themselves, and then to allow them to bring questions, etc., to the next consultation, or prior to the procedure, so that you're able to do most of it, but not all the details. The rest is backed up by the document, and then they're able to ask questions.
Thank you.
Okay, so there's at least 10 people here who have successfully defended the claim on the strength of a signed informed consent document. And if you ask me if that number was 1, it's still worth doing it, because you know, the cases that are being brought, especially for intraoperative injuries, are the amounts and the values of those claims are climbing and climbing and climbing. And it's partly because of inflation, and partly because of just complete misunderstanding of what patients are entitled to by the lawyers, who aren't particularly good. But having a proper signed informed consent, noting that complication is a risk and that the person has accepted it, is fundamental to defending those cases. And in fact, it's also the flip side. If you don't have it and there is a complication, it's almost certain that there is going to be liability, whether there was negligence or not.
Thank you.
Great. So we'll just do a quick recap. What is informed consent, right? It's consent, which is just agreement, right? But it's voluntarily given, so it can't be under duress. You can't coerce. You can't, offer incentives for somebody to do something. It's for the provision of a specified health service, so the person must know what specifically the health service actually is. given by a person who has legal capacity. So that's dealt with by the age and also whether or not the mental state and mental capacity of the user who has been informed of, and that's been given full knowledge of their health status, the diagnostic procedures and treatment options available, the benefits, risks, costs, and consequences. And here, where we say consequences, that's really partly based on outcome, and also should be made aware that outcomes are uncertain because medical practice is not an exact science, but also the consequences of the risks materializing. So in many cases, what happens is the informed consent says, we could perforate the bowel, but what does that mean to a patient? It means nothing. Perforate the bowel, that could lead to sepsis. You may have to have additional procedures within that procedure, or if it's not identified, then you may have other procedures afterwards, readmission, and sepsis is one of the consequences. So sepsis is a risk, but it's also one of the consequences of certain other risks materializing. And it's the consequences, it's all of that that's generally associated with each option. You don't have to be entirely complete with every single risk, but the material risks, the frequent risks do need to be discussed. And the right to refuse health services with an explanation of the implications, risks, and obligations of that refusal. And on the risks side, when we think about what's material, we gave this a different talk recently where we were talking about informed consent generally. And one of the practitioners got up and said, well, when I do this kind of surgery, it's mostly on minors, and yes, there's a nerve there, but I've never nicked one, so I just don't even tell them about it because I don't want to scare the parents, so they don't do the procedure. And that's very wrong, right? That is not the case of if you don't tell somebody about their health status because it could have a detrimental effect on them, that's okay. In circumstances like that, you absolutely have to, because even if the risk is low, the consequence is severe, and so it must be described. Why do we do it as the recap? It's ethical, right? It respects patient autonomy, the right to participate in their own healthcare decision making. It's also mandatory in the Constitution, legislation, regulation, and the HPCSA guidelines. There are serious consequences for not doing it: criminal prosecution for assault, civil litigation, and HPCSA complaints. And a recap on how. So written where it's required, and this is important for the earlier question on whether or not it can be verbal. The nature of the risks warrant a written record, then it must be in writing. And that's a catch-all. That's not in any specific legislation. And so, that's something you need to assess. But if there are serious risks, then it must be written. The patient has to be informed, so use the right language, consider the literacy level. It has to be comprehensive, and it should be a dialogue. So there should be questions and answers. And then lastly, this one, I think this is our input. They should be procedure specific. It's preferred over the general consent forms. And note that that forms and information sheets don't replace, but they can augment. So you can't rely only on the forms and information sheets. Here it is. Look at that. Let me know if you have any questions. You've got to at least have the discussion, and then you can provide the information sheets. You can have a lighter discussion if you have the information sheets, but you can't avoid it entirely.
Clayton, on this procedure specific question is here, there's lots, so we've got to have time at the end for at least 10 minutes for questions. Is a vaginal delivery a procedure specific problem? Should you give informed consent for vaginal deliveries?
That's a great question. In our view, yes. And where you see the nature of the risks warrant a written record, definitely should be in writing. And the risks of pregnancy and the complications that can arise in natural delivery are severe and relatively I mean, relative to
Common.
to the other serious consequences, relatively common, unfortunately. And so that is one of the ones that we have produced is for natural delivery, and it is a hefty one. I think it's eight or 9 pages.
Thank you.
Pleasure. So I want to just touch on one brief thing, and then we can go into questions, and that is complication or negligence. And I am not going to read any of the stuff that's on the screen because we don't have the time, but I'll just say this. An informed consent, it's not meant to be a defensive document for the purposes of avoiding liability. It simply also has that effect if done well. The purpose, of course, is actually providing the information so that the consent is real and respects patient autonomy. But if done well, it is a very good tool for avoiding liability. But it cannot assist you where a complication arises as a result of negligence. However, if you do not have the informed consent and a complication arises, then you will be very likely to be held liable, even if negligence can't be proven. But if you do have the informed consent, then it is on the patient to prove negligence, and that is an extremely difficult thing to do in most cases. So it's very valuable, but it does not assist you if there was genuine negligence that resulted in harm that was consented to. And then we're on to questions. So now we're in the right place.
Thanks so much. Yeah, I mean that's excellent. I mean the real point is to make sure that the potential complication is on the consent form and the patient has actually signed for it. That does help a lot in the events of a complication. But you obviously need to make sure that but it's not going to help you if there was absolute negligence. I suppose that's the real bottom line there. Hey. So we've got quite a few questions. In case of getting informed consent for C-section, how do you discuss life-saving measures such as hysterectomy? And how do you move forward when a Caesar is necessary, but the patient declines a life-saving hysterectomy?
Yeah. Oh, sorry. Should we just pick a couple and then I'll answer them? Yeah.
So that's actually probably a real-life scenario. I mean, that may would potentially happen in a patient like Freddie Skier, where patients had 3 or 4 previous Caesars, potential for an accretor, and there you go. You have to really tell the patient there is a hysterectomy. I don't know, maybe just document the discussion and move on from there. I don't know.
Yeah, it's the answer is around documenting the refusal. So the patient has the right to do that, right? To decline a life-saving hysterectomy for whatever reason, and you can't do anything about it. But you have to perform the Caesar. So if they consent to the Caesar but don't consent to a life-saving hysterectomy, you need to record the refusal and have them sign the refusal specifically, and then proceed. And then if they need one, that's you've got to have the courage to not do it.
Yeah, which is a difficult one for us. Yeah. Leon now has clarified his question on where mandates, meaning what health authorities in some business has demanded from the public to continue freedom of access.
Right.
Okay. Yeah, it's a difficult. I don't know if you want to discuss what you can.
And that's it's for me the simpler one is, and just using kind of COVID vaccination as an example, it's a choice. Unfortunately, it's a choice that becomes unmanageable if you need to travel, you need to do certain things, and the restriction is this. But if then it comes up to the individual. If the individual is willing to accept the treatment because they need whatever the treatment allows them to do more than their conviction to not have the treatment, it's up to them. But as a healthcare practitioner, it's to offer the choice and then let the patient face the consequences of whatever choice they're making.
Yeah. Another anonymous attendee asked about basically the issue of consent to termination of pregnancy and C-section. The 12-year-old can make a decision to terminate the pregnancy, but cannot give consent to C-section.
No, but it can. You can consent if you're 12 because to a C-section yourself, because you are pregnant and then you are a priori considered an adult. because of the pregnancy. Is that right, Clayton?
I actually don't know. I'm
I don't
really
think so,
interested in looking up the answer for that, and I'm happy to
These
give
two-
feedback on it. So I'd like to.
You know, we had a lot of patients at Groote Schuur where we'd be phoning the medical superintendent in the middle of the night to get consent for a C-section in a patient under 18. So from the mum. So I don't know if that has changed. I don't do obstetrics at the moment, so haven't actually been involved in that. But yeah.
But let us know, Clayton, when you have the answer.
Yeah.
My
Absolutely.
answer is yes, you can, as a 12-year-old, give consent. Next question, Steve.
I mean, it really comes down to how detailed must the consent be, all possible complications. And I suppose taking you from that, yes, I mean, you have to, you know, the most likely and possible complication. If it's reasonably a complication, put it in.
Yeah, it's the relatively frequent and the severe consequences should be in. But if you're not doing a procedure-specific informed consents, right, then at least just expand beyond saying, I've discussed all of the risks and complications. You can say, I've discussed all the risks and complications, including the possibility of injury to nerves, surrounding organs, blood vessels. You've caught most stuff with those three things. Then if you nick a bladder or something, it's much easier to say, well, yeah, it's an organ. It's in the list.
Yeah. I use the term viscera in my consent form. I mean, that covers nearly everything. So, but you know, the patient does need to understand that. I mean, there's a question about does a manual vacuum aspiration require consent?
Yes,
I mean,
of
that's
course, it's a
obvious.
procedure.
Yeah.
Next.
But it says that it require a signed consent form.
I would say yes.
Why?
Keep going, Steve.
Well, Peter, I mean, I wouldn't like to admit this, but there have been once or twice where the patients wheeled in and, you know, you've had a long discussion with them and, you know, suddenly the consent form wasn't done. But I mean, there is a sort of an implied consent that can legally be admissible, but I mean, that's very, very wrong. But does that help you at all? I mean, your documentation, all documents the discussion with the patient actually coming in and admitting to come and have the procedure. Does that help you at all, Clayton? Have you had cases like that where there hasn't been a consent form, but everything else has been done correctly?
Yes, we have many, in fact. And the best thing to help with that is contemporaneous note in the clinical record of the practitioner. So when you have the informed consent discussion, note in your handwritten records, had informed consent discussion, discussed risks, complications, benefits, just that. You don't even have to write what they are. If you just have that, you are in a 70% better position than if you don't write that and say, well, we definitely did discuss it.
Yeah, because I mean, sometimes it's an emergency, like a cord prolapse. You know, you've got your hand in the patient's vagina and you've been wheeled into theatre, and you know, no one's going to be able to take the consent sometimes. Yeah, a lot of questions. Yeah.
Now, let me just ask a quick question over here. As Steve says, we've kind of run out of time, but one important one: how do you handle a situation how do you handle a situation when the mother refuses to consent for an emergency Caesar for severe fetal distress? Can she say, no, I'm going to let the baby die? Is that kosher?
Unfortunately, yes.
Okay, that's that. Dave Bowen, Steve, you've just, there he is. If the consent for vaginal birth is 8 pages, how many pages for the C-section?
About 6.
6, all right.
Okay, sorry, the questions are moving about a little bit. Yeah, so informed consent in an unconscious patient given by CEO not doing the surgery. Your view. So the patient is kind of incapacitated, can't do the consent. You phone the CEO or the medical superintendent. They agree to the consent. I mean, that's legally binding and useful in the case of a complication or legal process following that.
Yeah, and that the escalation for that is in the National Health Act.
Okay. Okay, sorry, the questions are bouncing around.
Very quickly, while Steve's bouncing with his questions, can a woman withhold her HIV status positive from her partner? And what do you do? Do you have to, by law, inform the partner if you're aware that she is withholding this information? Happens quite commonly.
I I must admit, the last time I looked at that question was a very long time ago. Once upon a time I knew the answer, but I don't have it offhand right now. That's
Clayton, we're gonna have to get you back. We're gonna have to
somewhere
get you
covered in the
back soon.
cobwebs.
Yeah, look, I mean, to be honest, there's so many things coming up here. I mean, this is a whole talk in itself. What is the definition of negligence? And you know, we'd
there's
have to
daily-
go until about 9 o'clock if we had to start answering that
Well,
question.
well, I tell you what, you know, this is engendered. There's 200 people here, Clayton, that are on this webinar, and I think it attests to the importance of why it's important to have these talks. And I'm wondering if we shouldn't, in the near future, have people send us their questions. We send them to you, and you can have a question and answer session on these very pressing and very important and very topical questions. Do you think that's a good idea? Would you be able to do that at quite short notice?
Absolutely.
Okay, Steve.
Thanks very much. Yeah. Okay. Well, it is. What's the time?
18:01.
Yes, 6 o'clock. I think we'll bank these questions for both Matomi and the anonymous attendees. I think we'll have maybe even as soon as next week a question and answer session. And
I think it's wonderful.
yeah,
While the topic's hot, Clayton, by next week you'll have your informed consent for vaginal delivery that we can talk about, I'm sure. And these things are so important and of day-to-day importance to all of us clinicians, Steve.
Yeah, absolutely.
Would you like to
thanks?
Would you like?
Thanks so much, Clayton. You know, I mean, every time actually we do a lot of surgery, we do a lot of consenting, and every time you hear these talks, we
get cold feet.
We get a bit of cold feet and realize where we're failing ourselves and how lucky we are to sometimes sail by the seat of our pants.
Yeah.
Yeah.
So, and also, in addition to thanking you, and also like to thank Karain for her input, Steve. And we look forward to next week's presentation. Karain will let us know what it is, when it is, so it will be timely distributed. And thank you once again, Clayton, for your input and the possibility of us following up on this important topic for the very near future. Thank you, Clayton. Steve?
Thank you very much. And yes, thanks, everybody. And thanks for joining. And we look forward to seeing you all next week. And we'll let you know what it's about very soon. So thanks so much.
Thanks, Clayton. Bye-bye.
Bye.